Hello everyone. The last presentation explained the circumstances under which mistake of fact, judicial acts, accident and necessity could be pleaded as defenses when a person is charged with the commission of an offence under the Indian Penal Code or under any special law or local law. In this presentation, the circumstances under which infancy, insanity or intoxication can be pleaded as a defense will be explained. Section 82 and 83 of the Indian Penal Code give protection to children under a particular age from criminal prosecution and punishment. This is based on the principle that an infant is incapable of distinguishing between a right and a wrong, and so no criminal responsibility can be attached in regard to its deeds. Section 82 grants absolute immunity to a child below 7 years of age on the ground that such child is duly incapax, that is, incapable of doing a criminal act, which means that it cannot form the necessary intention to commit a crime. Section 83 provides qualified immunity to a child above 7 years of age but below 12 years of age if it is shown that the child has not attained the maturity of understanding to judge the nature and consequences of the act committed. If this is not proved, the child above 7 years of age and below 12 years of age would be liable for his criminal act like any other adult. How do you know the maturity of understanding of a child? It can be inferred from the nature and quality of the act, subsequent conduct of the child, and other related factors. The next defense is unsoundness of mind under Section 84 of the Indian Penal Code. It is a complete defense to a criminal charge which is based on the assumption that one who is insane is incapable of forming necessary mens rea to commit an offence. The act of an insane man is unintentional and involuntary, and no court can correct him by way of punishment. Unsoundness of mind or insanity is a disease of mind which impairs the mental faculty of a man. It may be in the form of idiocy, lunacy, madness, mental derangement, and every other form of mental abnormality known to medical science. Even an uncontrollable impulse driving a man to kill or cause injury would come within its scope. The important questions that arise in this connection are: how could insanity be detected, and what should be the demarcating line between sanity and insanity in order to extend the protection of law to a man from criminal prosecution? Though a number of tests have been laid down from time to time, yet the most notable one is the right and wrong test formulated in McNaughton's case. The famous McNaughton's rules, which formulate the law relating to insanity in most countries, is based on the replies given by the judges of the House of Lords to the questions put to them. The facts of the case are: McNaughton was charged for murder of Edward Drummond, Secretary to Prime Minister Sir Robert Peel. The accused was suffering from an insane delusion that Robert Peel had injured him and that he mistook Drummond for Robert and shot and killed him. The accused pleaded not guilty on the ground of insanity. The jury returned a verdict of not guilty on the ground of insanity. The verdict attracted considerable attention throughout England. The matter was debated in House of Lords, and it was decided to take the opinion of the judges of House of Lords for getting the law on the point clarified. Accordingly, the judges were requested to give replies to certain questions put to them. The answers to the second and third questions formulated the law relating to insanity in most of the countries. They are: every man is presumed to be sane and to possess sufficient degree of reason to be responsible for his act until the contrary is proved to the satisfaction of the court. To establish the defense of insanity, it must be clearly proved that at the time of committing the act, the accused was suffering from such defect of reason from disease of mind as not to know the nature and quality of the act he was doing, and if he knew it, that he did not know that what he was doing was wrong. Section 84, which recognizes the defense of insanity, was drafted keeping in view the Macnaghten's rules. However, Section 84 is more comprehensive because it uses the term unsoundness of mind instead of the term insanity. Because of this, there is no need to define the term insanity and artificially bring within its scope various conditions of mind which are not covered by the term insanity. Section 84 includes two different mental conditions in order to claim exception from criminal liability on the ground of unsoundness of mind. One, that the accused was incapable of knowing the nature of the act owing to unsoundness of mind, or that the accused was incapacitated by reason of unsoundness of mind from understanding what he was doing was either wrong or contrary to law. The first case covers two situations: involuntary actions and mistake of fact due to unsoundness of mind. The second case covers those situations where a man, by reason of delusion, is unable to appreciate the distinction between right and wrong. The legal concept of insanity widely differs from that of medical concept. Insanity at law or legal insanity means a disease of mind which impairs cognitive faculty, that is, the reasoning capacity of a man to such an extent as to make him incapable of understanding the nature and quality of his act. It excludes from its purview insanity caused due to emotional or chosen factors like irresistible impulse, continuous intoxication, etc. So far as the burden of proof in the context of plea of unsoundness of mind is concerned, the prosecution has to prove beyond reasonable doubt that the accused committed the offense with necessary mens rea. There is a rebuttable presumption that the accused was not of unsound mind when he committed the crime. The accused can rebut this presumption by adducing evidence, and the standard of proof is that of preponderance of probabilities. Even where the accused is not able to prove conclusively that he was suffering from insanity at the time of commission of the crime, the evidence placed before the court may raise a reasonable doubt in the court's mind regarding one or more elements of the crime. The court can acquit the accused on the ground that the prosecution failed to prove the guilt of the accused beyond reasonable doubt. The crucial point of time at which unsoundness of mind should be established is the time when the crime was actually committed. For this purpose, the state of his mind both before and after the commission of the act is relevant. The court has to pay due regard to the circumstances which preceded, attended, and followed the act. For example, a man was prosecuted for causing the death of his wife by inflicting 35 to 40 knife injuries. The court held that it was proved that the accused did not like his wife, wanted her to be taken away by his father-in-law, who promised to do it. He waited till the day when father-in-law promised to return but did not turn up, and when his parents were absent from the house, he killed her. When the neighbors complained to the police, he voluntarily accompanied the police to the station and answered the questions put to him coherently. The court did not accept the plea that he has a medical history of insanity and was taking medicine for it. The court held that the person was liable for murder. There is another rule called Durham's rule. According to this rule, an accused would not be criminally responsible if his unlawful act was the product of mental disease or mental defect. However, this rule is in operation only in the District of Columbia. Now, coming to the plea of intoxication, the law relating to this defense is contained in sections 85 and 86. Section 85 gives the same immunity to the man intoxicated involuntarily as Section 84 gives to a man of unsound mind. A man, in order to claim exemption from criminal liability under Section 85 on the ground of involuntary intoxication, has to establish that he was incapable of knowing the nature of the act, or that he was doing what was wrong or contrary to law, and that the thing which intoxicated him was given to him without his knowledge or against his will. Here, the man intoxicated cannot be said to have acted voluntarily, and hence he is not responsible for the consequences of his act. Section 86 deals with that class of cases where a man gets intoxicated voluntarily. Thus, where a man in a wedding consumed liquor heavily and shoots a boy who refused to move out of the chair and give the man a seat, the court held that he cannot plead the defense under 85 because his case falls under section 86. The law deems such man to have the same knowledge as he would have had if he had not been intoxicated. When a person commits a criminal act when drunk, he should be punished while he is sober. The justification for punishment here is based on the principle that intoxication is the result of voluntary act of the accused and he must answer for it. Thank you.